Okay, well, we might get started. Thanks for joining us for today's webinar. We're holding a short session today to talk about some of the changes that are coming to casual employment, which are coming into effect very soon on the 26th of August this year. You might feel like the laws around casuals only just changed, and you're right, we did see a lot of changes come into effect a few years ago, but the rules have changed again as part of a number of other changes that are coming as a result of the Closing Loopholes Bill, which some of you may have heard about in our past webinars and also articles we've published. We're focusing today on the casual changes because we're finding these are the changes that clients are asking us the most questions about, and they really affect all businesses who employ casual employees.
Hi everybody. So what we will cover today, the casual changes we're going to talk through today include changes to how casual work is defined, changes to the casual pathway to permanent employment, i.e. the employee choice framework, and some additional requirements in relation to the casual employment information statement. And as Meghan explained, these changes are coming into effect on the 26th of August, so very shortly.
So we'll talk about the definition, and we'll start by talking about the current definition. So under the current definition, you're considered to be a casual employee if you meet the following criteria. So the first criteria is that you are offered a job. The second criteria is that the employer makes no firm advance commitment that the work will continue indefinitely with an agreed pattern of work. And lastly, you accept the offer knowing that there is no firm advance commitment and become an employee. Now, the new definition is a little bit different. Under the new definition, you'll see that they still keep the need for there to be no firm advance commitment to continuing and indefinite work, but they also make you take into account a number of factors, including what they call is the real substance, practical reality, and true nature of the employment relationship. And then there's a second criteria, which requires the employee to be entitled to receive a casual loading or specific casual pay rate. So when you look at the two definitions, you're probably asking, what does this all mean, and how does the new definition change the way we look at what a casual employee is? So when you're looking at the current definition and how it's been applied, the courts have placed weight on what is stated in the employment contract. For example, if your employment contract referred to you being a casual employee, then you would likely be considered a casual. But the changes which are being brought about because of the new definition show a bit of a move away from that approach, as now the practical reality of the relationship is a focus, not just what's stated in an employment contract. So the new definition allows the parties to consider the practical reality and not just what is stated in an employment contract when an employee starts work.
So as Meghan explained, the new definition talks about there needing to be no firm advance commitment to continuing and indefinite work. So you can assess this based on a couple of things. The real substance, practical reality, and true nature of the employment relationship, and several other factors, including whether the employer can choose to offer or not offer work to the employee, whether the employee can choose to accept or reject an offer of work, whether it's reasonably likely that there will be future work available based on the nature of the business, whether there are other full-time or part-time employees performing the same kind of work in the employer's business as the work that the proposed casual usually performs, and whether the employee has a regular pattern of work. But just keep in mind that the list stated on the slide there isn't a full list, and there can actually be other factors apply. Also, just note that the existence of a regular pattern of work does not itself indicate a firm advance commitment to continuing and indefinite work. That's an important point to remember here. There's not really any single factor that's going to be determinative as to whether an employee is a casual. And employees engaged as casual employees, they'll remain a casual until a specified event occurs, which is the employee choice pathway that we have referenced earlier.
So let's look at an example of an employment arrangement and whether it would be considered to meet the new definition of a casual employee. So Emma is a retail assistant at a pop-up shop. She's given a roster each week setting out the shifts she is being offered for the next week. She's able to decide whether she wants those shifts, and she can let her employer know if she can't work them. She also works different shifts each week depending on when the employer needs her, and she gets paid a casual loading of 25%. When you look at all of the other employees that are working at the pop-up shop, they're also employed as casual employees, and the employer isn't sure how long the store will be able to continue operating after a few months. So the answer to this question should be pretty clear. Emma is a casual employee in line with the new definition, because you'll see there's no firm advance commitment to continuing an indefinite work, and she's earning a casual pay rate. So if we think of how the answer to that example might change, you could look at situations where, for example, Emma was required to work regular hours each week. So, for example, 9 till 3 p.m. every Monday to Wednesday. And if she didn't have the opportunity to reject work, then she may not be considered to be a casual employee. You could also look at if she didn't get paid a casual loading. This could affect the answer. If she was performing the same kind of work as other employees who are permanent, and if it would be likely that future work would be available to the business. So you need to be weighing up these things when you're thinking about what factors you have present in your arrangement and whether your arrangements meet the new definition.
So we also have some new rules coming in regarding how casuals can change to permanent employment. The changes mean essentially that there is now going to be a single pathway to how this can occur for eligible employees who are effectively working like a permanent employee to change to permanent employment if they want to. So this new pathway all focuses on the employee's choice to convert. Now, this replaces our existing casual conversion process, as you might be aware of, whereby some casual employees must actually be offered conversion to permanent by their employer. So under these new laws, employees will be able to notify their employer of their intention to change to permanent employment if the employee has been employed for at least 6 months or 12 months if they are working for a small business, and if they believe they no longer meet the new casual employee definition. There are a few circumstances though where an employee can't notify their employer of their intention, and that is if they are currently engaged in an ongoing dispute with the employer about casual conversion, or if in the last 6 months their employer has already refused a previous notification, or they've resolved a dispute about casual conversion.
If an employer does get a notification, which would be a written notice from an employee indicating that they want to convert to permanent employment, then the question is asked, what do they have to do? So before responding, an employer has to consult with the employee, so talk with them about what they're wanting. So they'll discuss certain details with the employee about what will change if the employee does become casual and the employer accepts the notification. So then once they've had that discussion, the employer must then respond in writing to the employee within 21 days of the notification, and they either have to accept the change or they have to refuse the change. So if they accept the change, then they have to make sure they include certain details and information in their response about what the new employment status will be. For example, whether they'll be full-time or part-time. They would outline what the new hours of work will be, and then they'll mention when the change will take effect. So that's a little summary on the slide of if the employer accepts the change, what they should do in terms of the information they should put in their response.
Okay, we'll have a look at an example because that can help us to understand how this may actually apply in practice. So we have John, who works as a casual plumber at a large plumbing company. He has been working for his employer for 8 months. His employer rosters him every week from 9 a.m. to 2 p.m, Monday to Friday. Is always busy, so has always been able to offer him work. Believes it is reasonably likely he will have ongoing work available, and they have part-time employees working in the same role. So John believes he no longer meets the casual definition. He tells his manager that he intends to change to part-time employment. John provides notification in writing, and his manager organises a meeting to consult with him. During that meeting, John explains why he believes he can change to part-time work. The manager agrees with this, and they discuss hours and when the change would happen. Now, in line with the required process, the manager responds in writing within 21 days of the initial notification from John and agrees to the change to permanent employment. The manager within that notification includes details of the new working hours and when the change will come into effect.
So that's an example of what would normally happen in an acceptance situation. But what about where an employer is refusing the change? So there's a few circumstances where an employer can refuse a change. If they are refusing the change, then the response again must include the reasons why. And there's a couple of bases on which they could refuse a change. So the first obvious basis would be if the employee doesn't meet the definition of a casual, but there may also be fair and reasonable operational grounds for not accepting a notification. So that could include if substantial changes would be required to the way in which work in the employer's business is organised, if there would be significant impacts on the operation of the employer's business, or if substantial changes to the employee's employment conditions would be reasonably necessary to ensure the employer doesn't break any rules, such as rules set out in an award or enterprise agreement that would apply to the employee. And an employer may also refuse a change if accepting that change would mean they aren't complying with the recruitment or selection process required by law.
Okay, now what happens if an employer get into a dispute in relation to this new choice pathway? So if they can't resolve at the workplace level, the dispute can actually be heard by the Fair Work Commission, like many other disputes. The Commission would generally try to resolve the dispute in an informal way, which again is quite usual for the Commission, for example, by mediation. If this does not resolve the dispute, then the Commission is able to arbitrate the dispute, which is a more formal process resulting in the Commission actually making a binding decision in relation to conversion. As we mentioned earlier, employees engaged as casual employees will in fact remain casual until a specified event occurs, which is all underpinned by this employee choice pathway and the employee's choice to change their status. Now, what this means is employment status will not automatically change. It will only change if the employee wants to change. So, for example, it will change if the employee and employer agree to status change under this choice pathway, or if the Commission resolves a dispute by ordering the employee be treated as permanent, if the employee and employer agree to status change under other processes set out in a Fair Work instrument that applies, or if the employee and employer otherwise agree to change status.
So if an employee wants to remain casual, it is important to remember that nothing will force them to become permanent. And if an employee does make a choice to change, then it is important to remind them that they'll no longer be entitled to a casual wage loading, and instead they will receive paid entitlements, and they'll have that job security that permanent employment provides. Luckily for employers, the status change will be forward-looking, so there'll be no back pay for permanent entitlements where an employee is correctly classified as a casual from the start. One final point to be aware of is that there will be a 6-month transitional period. So that means existing casual conversion rights and obligations will continue to apply until an employee is eligible under the new employee choice pathway. So after that point, employers will no longer be required to offer casual conversion.
So a lot of you may already be aware of the casual employment information statement that was released quite a while ago now. This statement is a document that an employer has to provide to all casual employees that has certain information in relation to their employment conditions. Now, this statement will be updated soon as a result of the changes that we are discussing today. So make sure you get a copy of the new statement from the Fair Work Ombudsman website when it becomes available, and make sure that you're giving this most up-to-date version to your employees. Now, importantly, something just to point out to you all is currently the existing requirement is to provide the information statement to new casual employees before or as soon as possible after the start of their employment. However, there are also now additional requirements to provide this statement at certain intervals to remind employees of their rights and their abilities to change to permanent work. So this means that this statement must now also be provided to casual employees employed by non-small businesses as soon as possible after 6 months of employment and 12 months of employment, and then every subsequent period of 12 months of employment. And then to all casual employees of small businesses as soon as possible after 12 months of employment. So you can see that there are some differing requirements there based on whether the employer is a small business employer or otherwise, so fewer than 15 employees.
So what do all of these changes mean for employers? So there's a couple of things employers should make sure they're doing. So they should make sure, obviously, that they're meeting the new definition of casual employment in terms of how their relationships operate in practice. They should be really clear with their casual employees about their employment status, not only in their employment contract, but also in how they correspond with their employees and in their conduct. They need to be careful not to categorise employees incorrectly, so not to call them a casual when they are actually a permanent. Employers should keep an eye on conduct that happens after a casual is employed, in considering whether they could now be permanent and no longer casual. Of course, needing to remember the obligations that employers have in responding to a notification and making sure they're dealing with those notifications correctly. And then providing employees with the casual employment information statement at those required times. And it's also a good idea to diarise the dates because they will sneak up on you quickly and you don't want to be having a breach because you haven't provided a notice to a casual in the time required. And then finally, it's important to review your employment documentation to ensure that your documents are reflecting the new law. So it's a good idea to check your contracts, see if they refer to the old definition or if they're referring to the old casual conversion process, because it's likely they'll need to be amended so that they reflect the new definition and the new process. And we can, of course, help with that if you do need help with reviewing your contracts and also your policies and procedures, which could also refer to those definitions and processes.
So just be wary that there will be anti-avoidance provisions aimed at preventing employers from improperly engaging casual workers. This means that employers must not dismiss or threaten to dismiss an employee with the plan to re-engage them as casual, make false statements to persuade an individual to enter a casual employment contract, or otherwise misrepresent the employment as casual. So in terms of the penalties that a breach may attract, companies can face fines of just over $450,000, or we can get up to almost $5 million for a serious contravention. So those penalties are up there on the slide.
So there are obviously a lot of changes that are coming into effect soon. So it is understandable that employers and employees have a bit of confusion in terms of what's happening. And if you do need advice on how the new rules will work, please get in touch. If you are interested in keeping up to date with employment law, you can always follow us on our Mackay's Employment and Industrial Relations Law LinkedIn page, or let us know if you'd like to be subscribed to our email database. There are always a lot of changes happening, so we try to keep everyone updated across those social media channels. Our contact details are on the slide if you do want to reach out to us. Otherwise, thank you all for joining us today, and we hope you can join us again.
Thank you so much, everyone. Have a good day.